Good morning. My name is Mohammed Abduroaf, and with me today I have Daniella Mair. She's a counselor, a family counselor. She's an expert in family law matters. And we're following up on a video we had last week. So today's topic will deal with child custody, key and contact arrangements. This isn't a Zoom webinar where we invited people to post questions. We felt it important that maybe we should try to educate and deal with this topic as best as we can. But if you are watching this video via Facebook Live, you're welcome to post a comment or a question and we will try to address it. So this video is obviously live and the only other way to watch it will be via Facebook Live. So if you are watching it via one of our pages and our platforms, please go ahead and place a comment and please feel free to share this video as well. Someone might find it useful. Daniela, how are you today?
Important, and yeah, it's an absolute pleasure to be here. How are you?
Okay, I'm all well, can't complain whatsoever. Thank you, Daniela, for that. So, Daniela, let's get into the topic. The topic is child custody, key and contact arrangements. I'm an advocate, so I specialize in these type of matters. You are a counselor, family counselor. You deal with this matter from a different point of view. My job is to legalize matters, take it to court, have orders being made. Your job, I would imagine, basically is try to resolve issues, educate people, and at the end of the day is to have a happy family and to have a happy home. Am I right on that?
100%,
Okay.
definitely.
So Daniela, let's start from the beginning. Okay, maybe you can assist us. What type of problems generally come to your door? Maybe that will be the foundation for us to move forward.
So obviously, when a client first contacts me, it is usually very tense and very stressful, and nobody really understands what the process is going to be. So somebody will say, you need to go for mediation, and immediately, even though it sounds like potentially a good idea, nobody actually understands what the actual process is and what they're trying to achieve. So what my job is really is to sit them down and to explain everything and to discuss exactly what we are going to do with the aim of coming to an amicable resolution, so somebody like yourself can take that document that everyone signed and agreed upon to court to make it an official order. So what I'd like to start off by saying a little bit is, what is custody? And this is a huge issue because a lot of people don't realize, and if you think about it, when you get married and you have children, you never expect that things are going to go this way. So we think about custody, and also when we are influenced by things like Hollywood and the movies, you don't actually understand what the real basis for custody is. So I want to start off by just differentiating between the two different types of custody. One obviously being legal custody and the other being physical custody. So the difference between the two obviously is who has got physical custody of a child or of a minor. Where does this child live primarily? And primarily meaning most of the time. So often I get clients come into my office and both of them want to be primary parent. What is primary parent? What does it mean? So when we're talking about physical custody, that is what we are talking about when we nominate a primary parent. Where is the child residing primarily for the majority of the time? What people don't realize is there's a difference between that and legal custody. So if a child is primarily living with a mother, for example, and only sees the father potentially every second weekend, that means that the mother is the primary caregiver and has physical custody, but legal custody is always joint and nothing can be decided without both parties agreeing on something. So I just want to differentiate between that, because a lot of people think, well, if the child's living with me, I don't need to ask permission to change schools, to change medical aids, to move to a different area. But that is like, couldn't be further from the truth. And that is a huge point that causes a lot of tension.
No, Daniela, I'm with you on that because a parent might be caring for the child predominantly. Sometimes it makes sense depending upon the age of the child. The child wakes up at the Pacific parent's home, goes to school close by, etc. And the only practical way for the other party to form part of the child's life is to come see the child maybe every second weekend, maybe a day in a week. Obviously, if everything could be perfect and both parents live next to each other, then the child would have been with one parent half the time and the other parent the other half of the time. So it doesn't mean that if one parent has primary care over the child, the other parent is not capable of caring for the child or should have a lesser say over the child's life? Is this because of the facts of the situation? That's how it applies. So Daniela, thank you for clarifying that with us. So how do you get past that hurdle once you explain that to the client? Is it easier to deal with the matter going forward?
It depends completely on the client. So very often, as we mentioned last week, when a couple commits to the process and realize that the children are the focal point and what is in the best interest of the child is what needs to happen, then they kind of do come to the party and realize, you know what, the name primary parent doesn't make or break anything. And it's up to me to put my stuff aside to allow my child to progress in the best way possible. And I still can have as much or as little involvement as I'm prepared to put in to my child. There was a question that was posed where somebody said it was very difficult for them, but they just felt like the child would have a better chance at life, really, and was struggling a little bit with schoolwork. And the primary parent in this instance had been the primary parent for the past 14 years and thought, you know what, I love my child so much that I know that if this child had to move to the other parent, they would be much better off because that parent was able to provide a much better environment to focus on the things that were important. So it's very challenging, and it's very, very rare that we have a situation where somebody is willing to say, the other parent can offer my child better. I'm going to put my pride in my pocket and let things be. But it's very rare that happens, but we would like to see more of that. So the other thing is that very often when I get clients that come in hot-headed or angry or hurting or whatever, it's very difficult to get this point across. And in these kind of instances, sometimes I just avoid the primary parent altogether. So if there is some situation where it's possible that parents can have 50-50 access to their child, and this is physical custody I'm talking about, then I try and not name anybody a primary parent, just to try and not give anybody more power, so to speak, over the other parent.
Or maybe use a technical term like co-primary parent, so both of them are co-primary parents,
Exactly, but I think what's very important to remember in drafting of parenting plans is you need to really know your audience and you need to judge exactly what might come up in the future as a sore point and might cause future dispute, and try and iron those out immediately so that should it ever come up, that there is no basis for it and nobody can really argue because everybody knew upfront what was going on. So naming somebody a primary parent might be agreeable today, but in 6 months' time, that might cause an issue, and we never know that, and we try very hard to avoid that.
Yeah, I can imagine it can cause an issue should a mother apply or father apply to a school, and that specific parent will believe I'm the primary caregiver in this documentation, made an order of court, therefore I should have the final say. But that isn't the case. It won't work that way. So those who are watching this video live via Facebook, please feel free to leave a comment, and we will try our best to answer it. And if you can share, please do so. So Daniela, I have that experience a lot whereby some fathers, they come to my office and they want to litigate, and their basis for litigation is that they feel that should they not litigate, although they don't have much of a case, they'll have to explain to the child in a few years' time that why did I do nothing about the matter. But that's a bit dangerous because, each case is different. Sometimes it's not in the child's best interest to be in the primary care of one parent as opposed to the other parent. So you shouldn't necessarily fight or argue or litigate for the sake of litigating in order for you to explain to a child in a few years' time that I did try my best. But sometimes trying your best and fighting and throwing money at legal fees can cause harm to the child more than actually doing any benefit or better the situation. What is your view on that?
So I'm going to backtrack a little bit, and I understand what you're saying, and I agree. Like I've mentioned before last week, I went through a divorce, and as a divorcee, I think when it comes to children, you want to absolutely be able to say to them at the end of the day, when they're old enough, that we did try everything.
Yes.
But that trying everything really must be reserved to the marriage. So why did you get divorced? Was I not important enough to you to try? And at that stage, you want to be able to say, we tried everything. We stayed together. We went to counseling. We had X amount of years of therapy. At the end of the day, after trying everything, we realized we couldn't resolve it. Once you've made a decision to separate, that is when you need to remove those kind of emotions from the equation. Because all we need now is to say, okay, we tried everything. Nothing was going to work for us. We've realized that for any child to live in such a tense environment is definitely not good. So we're going to separate. So why would you bring that stress back into the child's life? You know, it's at that point when you realize we need to put our stuff aside, and now we focus on the well-being of the child. And I'm telling you now that when the child is old enough, they're not going to say, did you try everything? They're going to say, why is it that when you separated, you were all fighting over me, or who I needed to be with, or what I needed? And that's when we open the door to, did anybody even really ask me what I needed? So that's why I'm saying I backtrack, is because we need to separate it completely. Once we part ways, that is the time to basically go like that and put the child straight in the middle. And everything needs to be thought, like the child needs to be the center of every single action and communication going forward. So should you go straight for litigation, like you say, when you don't have a case? Again, that's all completely about ego. It's about winning.
Yes.
And that's not the right attitude to have, really, because the child needs to be the one that wins.
No, you're right on that. So, Daniella, let's unpack it. Key and contact arrangements. What's the first issue? I would imagine the first issue that must be decided upon is by who does the child primarily reside at. I think that's the first topic. And then from there we can go to child maintenance and guardianship issues and so on. So how do you generally determine who should the child primarily reside with? For argument's sake, the parties were living together. The child is most probably 10 years old, so he's past that age of nappies and needing somebody to care for him all the time. Mom and dad both work. They say they have the same job. They both work in the evenings and during the day. A nanny looks after the child during the day. How do you come to a point and to determine who should be the primary caregiver? Because both of them can care for the child just as well as the other one. How do you deal with that?
Yeah, it's a very, very tricky scenario, because it's not very often that each parent is 100% equal in their lifestyle. But let's just look at what determines a good primary caregiver. So there's obviously various factors that we consider. The first one is the economic position of each parent. Who is in the better situation to be able to care for the child? So I'm putting your question to the side where everybody's equal, but I will get to that. So the factors are economic, the mental and physical health of each parent. So who is more emotionally equipped to deal with the child? Who is more physically fit? Is there any disability or any area of concern where the parent might not be able to raise the child as well as another parent? And then obviously a very big one is the child's age and gender. It's very rare, again, that we would put a 2-year-old daughter primarily in the care of the father, and that is just generalizing, because there have been many cases where that has happened. But we look at the child's age and we look at the child's gender to make that determination as well. So what we have is we break it up into ages. So when you're talking about an infant child, generally speaking, the mother is named primary caregiver. And those are for very obvious reasons. As the child starts getting older and older, we look again at who might be the best parent for that child at that child's stage of life. But another thing that I just want to mention is that it's very important, and a lot of people forget, is that as children grow up, their needs change. I mean, I had an instance with a little boy who was very attached to his mother. And they were extremely close, and the mother was always primary. And then all of a sudden, they came to me for therapy, because they all of a sudden weren't getting on anymore, and they were bashing heads, and they couldn't understand what was going on. Simply speaking, the boy had gotten to an age where he was so desperate to be with his father, and so identified with his father. The mother, on the other hand, was just the parent that he was used to bossing him around, and they had not attachment, sorry, that's the wrong word, but his needs had changed.
Yes.
And luckily this couple could identify that, and after we had discussions, realized that the stage of life now meant that it might actually be better for the child to now switch over. And that came with a new draft of a new parenting plan and all of that. So when we go back to your question and we look at who would be best to care for the child primarily if both are equal, that is a huge problem, because you get two different kinds of people: the agreeable couple and the disagreeable couple. The agreeable couple will come in, we'll have a couple of sessions, we'll talk about it. Everybody again will get to say what they have to say about being the one that should care for the child. And most of the time with agreeable couple, we can come to a very solid 50-50 agreement. The disagreeable child, it can go on forever. I had a couple that I mediated that had been in mediation in some way for the past 10 years. And that is just ridiculous. You know, nobody could agree. It was a huge issue. And that is the stage where somebody like you have to step in. And when you do step in, we say, okay, well, we've tried to mediate. Both are adamant that they need to be primary. Both present exactly the same credentials, let's call it. And we can't figure it out. We can't understand what to do. So that is where the legal side of things come in. It goes to court, social workers come in, they try and make determinations. And then, unfortunately, like I said last week, that is where it gets taken out of your hands and the legal team basically take over. And whoever fights harder will then win the custody.
And that's unfortunate, because now it depends upon other factors. Other than what's I think maybe then you move away, because then you start looking at, where's the best lawyer, who can afford a better report, and so on. Daniella, and maybe if things are all equal, then we maybe look at other things. For example, what does the child want? What is his preference or her preference? And also maybe, you're right, something interesting you mentioned earlier on the gender of the child. What's a preference? If it's but then we can maybe look at some external factors. What will make it much better? Who lives closer to the school? And stuff like that. But it's difficult. It's extremely hard, because whatever one argument comes in favor of one party, the other party comes with another argument. Yes.
Exactly, and I think that's where, again, it's so important to define between our different jobs, because when we're talking about the emotional side of things and the practicality, like the perfect example that you've just used, who lives closer to the school, to me that makes perfect sense. And I think to any social worker looking at it, it would make perfect sense that it takes a child 5 minutes to get to school with mom, but with dad it takes a 45-minute drive and they have to wake up at 5 a.m.
Yes.
That is not conducive to a strong mental health of this child over a long-term period. But again, then the parents will come in and they'll start fighting about it. So that is where we do definitely need the legal people to come in, to not say, oh, I understand it makes you feel this way, but this is how it is. This is what needs to happen. And in order to prove that, we're going to get the social workers in. We're going to order the social workers in. And you know what, Mom, you don't like the idea that we've come up with? It's too bad. We gave you the opportunity to rethink it, to express how it makes you feel. We can't come to a resolution, so I'm sorry, we'll make the decision for you. And another thing I just want to mention is that this is exactly what we use parenting coordinators for, which is something that we didn't speak about before. And I want to just quickly, this is a perfect time to differentiate between a mediator and a parenting coordinator. I happen to also be a court-appointed parenting coordinator. And what that means is, once we've drafted the parenting plan, once we have got a amicable care and contact arrangement through mediation, you name somebody as the parenting coordinator just for the court record. And what this means is that when we get to a situation later along the line saying, the children have all of a sudden got an extra 2 weeks of school holiday that wasn't accounted for in the parenting plan, and now we can't agree on who should have the children now. That is a stage that you bring the parenting coordinator in to resolve that particular dispute. And again, as with mediation, even though parenting coordination has got a little bit more power, everything can be I can mandate things, I can suggest things, but you cannot enforce them. So we say, okay, the parenting coordinator will take care of this. This is the issue. this is her decision or his decision because the parents can't. Now that's the final order.
Now, I can see the benefits of having parenting coordinator. I think in the previous term they used to use it as a facilitator and so on. But
Correct.
it's
Yes.
very useful because, why must you always go to court? You can have your own person to deal with the matter. It's much cheaper also. You just pay the parenting coordinator, resolve the matter, and move on. And obviously, if one party maybe gave in at this point, then the other party must give in at the next point. Daniela, we have a comment on our Facebook Live. It says the following: I am in this situation. My kids stay with the dad primarily due to them staying close to their schools. Their father excludes me from everything purposely and does not want to put the kids' needs first. The father does have an ego issue. What can I do? And it goes further. There is no court order, only a verbal agreement at this stage. So there's an agreement that the kids stay with the dad primarily, but the father doesn't include the mother regarding matters concerning schooling and so on. What type of advice do you have for the specific person?
I love this question for the simple reason that it shows you how important care and contact arrangements are. And I very often get situations where couples come in and say, oh, you know what, we're divorcing amicably, we like each other enough, it's all about the child. It's never the case. Never. You never know what is going to happen. That is why it is so important to have something drafted so that it's official, at least just so that you've got something to fall back on. So advice would be to try, it's very difficult at this stage, but to try and get something drafted. Because yes, you may have a verbal agreement. Unfortunately, let's say the agreement is that you're going to have reasonable contact with your children. You're going to be involved in all decisions regarding the children, and you're going to get to see them twice a week and every second weekend. Wonderful. What happens if somebody breaks that? So if now the verbal agreement was that, and now the father is excluding you from the lives of the children or the decisions, you have got nowhere to go to. Whereas if you had it all drafted, you can go straight to family court and that other parent would be in breach of your care and contact arrangement. So in terms of not having one at all, I don't know. What would you say?
Yeah, I think the problem is if parties come to these verbal agreements, then there's two versions of an agreement. There's one person's verbal understanding of this agreement in his brain and the other understanding of the verbal agreement in her brain. So they both have different definitions of the understanding and the agreement. And as time goes on, those subjective understandings of the agreement changes and it develops to different understanding scenarios. So I agree with you, and what needs to happen in this specific case is they need to see a mediator. The mother needs to enforce it, and if they cannot come to an agreement, going to private mediator whereby she and him sit on the same table with a third party trying to resolve this matter, then I would advise the mother to take this matter to the children's court, and the children's court can enforce mediation, and try to agree upon a parenting plan. I don't know the age of this specific child or these specific kids. However, this matter will go like this indefinitely for the next few years until the kids are out of school. So my advice is, see a professional, draft a parenting plan with the necessary terms in their parenting coordinator and so on. If you cannot agree upon that, please go to the children's court and try to get them to enforce that specific agreement.
I just also want to mention for this particular question is that it's a very different scenario to somebody the beginning of the process where we're trying to determine who should be primary. Once you are dealing with somebody that is already primary, verbally agreed upon, it's now going to be a lot more difficult because it's not now deciding who's going to be what. It's now challenging what's already been going on. So you'll probably find that the father in this instance is not going to be open at all to mediation because he's already won, So I think a visit to the family court is definitely something that I would recommend, and also perseverance. It's not going to be easy.
Yeah, and also the difficulty is, Daniella, we don't know how long the situation took place. So if he always had a final say regarding the schooling, and if he is a person paying for the school fees, and that's a very important factor because people believe if I pay the school fees, I decide where the child should go to. So it can be very challenging. Therefore, external assistance is required, and if need be, the court can look at both sides of the story and both parties put their case forward, and the magistrate obviously can make the final decision. The challenge with stuff like school fees and what school the child should attend, It seems to me the courts don't much get involved and tell you the child should go to school A or school B. They don't get much involved over there. They basically leave that to the party to determine. They can get involved in the amount of maintenance they get paid, but they can't get involved as to what specific school. I mean, how do they know? So it becomes very difficult. That's where mediation and facilitation and the parenting coordinator comes in. Daniella, moving on now. So we decided now, we debated and we went to court and all that stuff here, fictitiously now, of course. Now we decided who is a primary caregiver for the child. Then these other problems arises now. You know, what type of contact rights the child should have by the other parents. So we have a few scenarios. We have the normal scenario, every second weekend, maybe midweek contact. And then we have the other scenario, meaning dealing with shared contact, you know, 1 week with one parent and 1 week with the other parent. Let's tackle both of them, but the first one is, what is your preferred situation? 50-50 or?
I prefer any situation that parents agree on. Yeah. So I do not have a preference personally. We have to look at the child. So one of the human rights that a child has, children's right, is access to both parents. So if we use that as a fundamental basis, we realize that what is in the best interest of the child is to have equal access to both parents. And when we're talking about just the generic equation here, so let's leave abuse situations out, let's leave all that kind of stuff on the side for now and go back to your scenario where both parents are basically equal, then 100% the preference in that case would be to have some sort of 50-50 access. Now, what happens in this kind of a scenario, again, is what is exactly 50-50? Some people say, well, I need the child the whole week, and then you can have the child for the next whole week. Some people do like a 5-2-2-5 split, so Monday to Friday, then the next person has the weekend with the whole week, then that swaps again. So the child is 5 days at one parent, 2 days at the next, 7 days at the, it's complete chaos. So what we have to think about is who is this child? What endurance does this child have? What challenges does this child have? What is the age of the child? And I say that because, yes, it would be a great, simple, perfect world if I can say, I have child in week 1, you have child in week 2, and so forth. But is 7 days away from one parent really in the child's best interest? Can they cope with being away from mom for 7 days or being away from dad for 7 days? Which is why we always come back for some reason to breaking the week up more. So in terms of having 50-50 access to both parents, that is the ultimate goal. That is what we strive for. That also in turn then makes maintenance issues a lot easier and a lot clearer. But I think the most common kind of parenting arrangement that we see, and this goes back into the whole history of, I don't want to sound rude, but like into what mothers do for children compared to fathers and that whole gender stuff, you know, I'm not even getting into it. But traditionally, mother has always had custody of the child, and mother is usually awarded primary care of the child. So what traditionally happens is that child will live primarily with mom and see dad every second weekend and one midweek visit. And although what this is doing is denying access to the father as much as the mother, it might be better for the child because the child at least can focus on school in one place, not have to wonder what the schedule is, and know that when they are with dad, they at least have the time to build a quality relationship instead of having the stress of, oh, shoot, I forgot the PE togs, or oh, dear, I forgot that I needed to pack the school lunch. So it's very, very difficult for the child. And I've had a client who, I said to him, what is the biggest challenge you face with your parents getting divorced? And he sat there and he said, my life feels better because they don't fight anymore, but it's just terribly inconvenient. And that's what we have to look at, is why what we do impacts our children so much, and what can we do to make sure that their lives are as convenient and as normal, in inverted commas, as possible, you know? So when it comes to what is the best parenting plan, it is completely unique and specific to every single case that comes in.
Daniela, you're right on that, and I would actually advise the client that as well, because every family is different, dynamics are different, people's income, age of the kids, siblings, step siblings, where they stay, it's all completely different. And I think you're right. The best parenting plan is one that the parties agreed upon and they're all happy with. Um, you can have a parenting plan drafted or by the best of lawyers, advocates, attorneys, social workers, psychologists, etc. Beautiful drafted, chapter 1, chapter 2, chapter 3, dealing with the first 3 years till school till high school. But if it's not workable and people are not happy with that, it's a waste of paper, unfortunately.
100%. And again, people need to realize that as the children grow up, you might need to readdress it. That just because in 1987 we came to this agreement, that's not valid or relevant anymore. And we need to be able to sit down again at a later stage and relook at everything, because now we're dealing with a different person. Same child, different person.
No, you're right. Daniela, the comment on Facebook, the person to whom we answered the first question says, thank you very much. I will take your advice for a mediator/parenting plan. So wonderful. We have another question. It says, hi, Daniela, I have a problem. My brother and his girlfriend broke up and she's not looking properly after the baby that is 3 years old. Every time I fetch the child for a visit, she is very thin and has a bad smell. She is at the moment with me. Can I apply to adopt? So basically, her brother and the mother of the child, they're not together anymore. Child is living with the mother, and now whenever the sister collects the child, the auntie collects the child, she's thin and she smells funny. What the sister wants to know is, can she adopt the child? What is your take on that?
My take on that is to go straight to the family court, to basically file a complaint. I don't know what you call it. Yes. Sorry, you can help me with that. But file a complaint again about the welfare and the care of the child and the well-being of the child. Yes. From there, what would happen? You can correct me if I'm wrong, but what would happen from there is then it would be put on the court log, and a social worker would be sent out to go and assess the situation. What we do whenever a social worker is really brought into the equation, their primary job is to determine for the court, for the magistrate, whether a particular child is in need of protection or not. So if they were to go out and they were to do their investigation and discover that there is an issue, then they would immediately report back with a recommendation that this child is in need of care and protection, and the child will be removed from that parent. The child then would go into a welfare situation. So when it comes to can it is the aunt, am I right?
Yes.
That wants to adopt the child. So if it comes to can the aunt adopt the child, then I'm afraid I'm going to have to leave that question to you. But technically speaking, in order for an adoption to take place, you would need the agreement of both the parents. So when the child is actually physically removed from their care, I'm going to have to leave that over to you.
Yeah, no, that's fine. So maybe on the issue of adoption, adoption is a very serious legal remedy, because it basically means that child no longer belongs to the family of that parent that gave away the consent. So, for example, if the mother and a new spouse or the auntie adopts the child, it means that the mother's side of the family is no longer connected to the child, and furthermore that the mother has no rights over the child, and the child, for all intents and purposes, belongs to the aunt. So I think adoption might be something that's out of the picture. The question I pose over here is, there is a father involved over here, and why doesn't the father enforce his rights? So the simpler answer could possibly be that the father should now apply for custody, etc. Regarding what you mentioned, yes, it's a valid advice you mentioned to the person going to the children's court and making an application and basically stipulating that the child is in need of a care and protection. So that's the application form, you tick out on that. And then obviously a social worker will get involved and he will investigate the matter, call both parents in, mother and dad, and then they'll decide if the child is being neglected and the child is in need of being in a place of safety, they will put the child in foster care or have an aunt or an uncle possibly look after the child until this whole matter is finalized. It's quite serious. So that's one aspect. The third aspect, which I can maybe say, is if this aunt believes that she can care for the child better than the mother and the father, she can apply to court in terms of section 23 of the Children's Act. assigning parental rights and responsibilities to a third party, interested third party, here being an aunt. So that is possible. So it seems to be me, and I speak under correction, obviously, that the father isn't really caring after the child, the mother isn't caring after the child. We have an aunt who is capable for caring for the child, so she has those specific options. As you mentioned, the children's court, yes. Adoption, I think that's a bad idea. And thirdly, make an application to court for her to be assigned parental rights and responsibilities. Does that coincide with your advice, Daniella?
Does, and also just on the adoption thing is that once we have a court order that the child will be in the care of the aunt, I think that is good enough. And I do agree with you about the adoption maybe being a bad move or being unnecessary, because also once we've got the court ordered plan that the aunt is going to be the one that is responsible for the child, the mother of the child can't really go against that, because if she does, then she would be in breach of it anyway, and then at least we have the fallback of going back to the court. So I think that's good enough.
This could be a typical example where a psychologist answers the question, going to court, so there's not much money we can make as lawyers. So the question gets posed to a lawyer, then we answer it in such a way that we can make money off the deal, and do court applications. So this was a typical example. If you go to a builder to fix a door, he'll knock the door open. If you go to a locksmith, he will use a key to fix it. Anyway, that's some joke making.
The builder will also knock down the wall.
Yes, and make some money off that as well. Okay, so if there's any further questions on the Facebook platform, please feel free to post it. We are streaming live on various Facebook platforms, and we'll try our best to answer that. So, Daniella, moving forward, so we have the primary care sorted out. We have the contact and care arrangement sorted out over there. Where to go further beyond that? Now we have to go to issue concerning if there is problems. Maybe before that. Then there are those special days, those days regarding Christmas Day, Muslim Eid Day, Mother's Day, Father's Day, the children's birthdays, and those specific days. How do we get past that now? Okay, we made an understanding. Mom has primary care, perfectly fine. Contact arrangement will be as follows: 1 week, 1 week, 2 days, 2 days. Now we're dealing with the nitty-gritty. Father's Day, Mother's Day, and those specific days. And that can be a problem, because a mother might believe, I want to have the child overnight by me on Mother's Day. But the father said, no, my Father's Day is an important day, but I only want to have the child for a few hours, if it falls on his day. Do you come with those type of problems to your desk?
And I am an absolute firm believer that once we get to the fact that we are drafting a care and contact arrangement, these are what I was talking about earlier. They are absolutely, without a doubt, going to become issues in the future. So they're dealt with now. And again, so what we do is when we're talking about making a care and contact arrangement, it doesn't have to be the same for both parents. So what we usually do is say, okay, the child will be with the father on the father's birthday, and similarly with the mother on the mother's birthday. It doesn't matter where in the schedule we are, that day is set aside where you can spend with your child. Depending on the situation, when it comes to the child's birthday, you maybe have a family that are still very close, where they're happy to share the day and all do something together, which then gets written into the plan. Or 1 year, the father will have the child when the child wakes up until lunchtime, and then goes to the mother for the rest of the day. But then the following year, it will switch around, so that it's just kept fair. And that, I think, is just really the way that we go, is whatever happens this year, next year automatically happens the other way around. When it comes to Christmas, maybe the mother wants the child every Christmas Eve because that's important to her and her family, and the father's happy to have the child every Christmas Day. If they agree on that, then that's fine. Then there's no issue. That happens every single year. If they can't agree on that, and Christmas Eve is as important to both of them, then 2020, I have Christmas Eve, 2021, you have Christmas Eve. And we keep it going like that. But then we break it down, because someone will say, okay, well, this year, then I'm going to have Christmas Eve. But now they both want Christmas Eve this year. So yes, we agree that we're going to switch them around year by year, but now who gets this Christmas Eve? And this is where we kind of work backwards, and we say, okay, Dad will get Christmas Eve because we've just discussed that Mom's going to get, I don't know, school play night or whatever. And Dad's let Mom have school play night. Now it's time for Dad to win something, and it's kind of like a manipulation almost. And that always works back to who eventually gets called primary. So we have a situation and we finally say, okay, you know what, I agree, mom can be primary caregiver. I'm like, well, that's very big of you. That's very nice of you. Thank you very much. Mom, dad just agreed to primary. Really, is it going to make such a big difference if you let him have Christmas Eve this year, you know? And this is how we kind of like slot it in. But yes, school holidays is one big thing. Who's going to get the kids for the school holidays? Religious holidays and birthdays, Mother's Day and Father's Day usually is always spent with the mother and father. And we hope for the best, really, that everyone can agree on that. But we definitely put that down immediately.
Yeah, the challenge I have is that, or the problem I see, it doesn't mean that you have a well-drafted parenting plan, things will go well. For the simple example, I done a matter some time ago, a few years ago, where there was counsel on both sides. So we litigated the matter. They had an advocate and attorney. We had an advocate and attorney. We spent hours drafting this well-drafted parenting plan. And it seems to me that the problems arises not necessarily where primary care is and so on. The problem arises regarding that Mother's Day, that Father's Day. That is when you get the phone calls. You know, we get phone calls on Christmas Eve because now there's a dispute. And that's what I'm trying to say is here is that fine print those minor things that causes problems in the future. So you can have a well-drafted parenting plan, as I said earlier on, but if the parties do not want to be reasonable and they want to argue, they want to fight. So if the parenting plan, for example, says that the father will have, example, contact with the minor child on Christmas Eve, as the case may be, but you don't stipulate, example, when does contact come, when do you do this, the swap over, and you do not deal specifically what happens the following year, etc. Those are the nitty-gritties, and sometimes one clause that is not well drafted and well explained causes the parties to spend thousands of rands in the High Court on Christmas Eve, because now the father made plans for Christmas Eve with the minor children, with his family, and they WhatsApp each other, and one party disagrees. Then it ends up in the High Court, the judge in the High Court's desk the day before Christmas, and we're litigating on that topic. I'm not saying we shouldn't litigate upon it, but it's so unnecessary. So, Daniella, my point on that is, we can draft this perfect parenting plan, but the problems arise not necessarily with primary care and, this and that and that. The issues basically arise regarding those finer points from Mother's Day, Father's Day, the birthdays, and so on. Okay. I'll move on that specific topic. And I think we can also say that the parenting coordinator will play a role where that is concerned. He or she will assist the parties.
Absolutely. I mean, like you said, even if we say Christmas Eve switchover will happen at 5 p.m. and mom's half an hour late, that's definitely where a parenting coordinator will step in and be like, and have to take control of that situation.
Yeah, so they'll be busy on Christmas Eve and on those specific days. Those are the problematic days. So, Daniela, so we have this wonderful parenting plan drafted. And then the other problem comes over here regarding extramural activities, because the mother believes that a child should do swimming because she's a good swimmer. The father most probably doesn't like swimming so much, and he wants the kids to do soccer and rugby and other sports. Disputes arises because the parenting plan doesn't necessarily deal with those type of issues. How do you resolve disputes regarding extramural activities? But you need to go to parenting coordinator. How would you resolve that issue? Because the mother wants the child to do soccer or swimming, and the father wants the child to do a different sport. That is difficult to deal with.
It is difficult to deal with, and this is where I rely so heavily on the children. So in this kind of a situation, in the kind of practice that I run, often the parents will say, okay, well, we'll have a session and bring the children into it and actually listen to what they have to say. Beyond that point, I mean, I'm very involved with the schools as well. So I would definitely make a phone call to the sports teacher or the soccer coach or whatever to find out from their point of view, does the child actually enjoy swimming? Are they any good at swimming? Are they good at soccer? My son, for example, he loves soccer, but he doesn't understand it. So every time he goes to soccer and somebody tackles him, he cries because he had the ball first. That causes too much stress for him. So in that kind of a situation, let's pretend his father was adamant that he did soccer. I would say, look at what it's doing to him. Yes, you want that, but what does he want, So it is very difficult. And this is where, again, it's all about winning and losing. If we can focus on the child's needs and what they actually enjoy doing, then we can answer that question a lot easier, but then it's up to the parents to actually listen to that. Another thing I just do want to mention, though, is that I speak a lot about children's rights and their opinion, I'm absolutely not saying at all that children should run the show. So if dad says, I want my child to do soccer, and mom says, I want my child to do swimming, that child should be forced to do both of them, at least to try, in order to form that opinion. So it's not just, I don't really feel like I want to do swimming. Okay, my darling, you don't have to. That's not the case. If we're going to listen to the children's opinions or something, they have to speak from a place of experience. And it's up to both parents to allow the children the opportunities to succeed and fail, to learn what they like and what they don't like. And ultimately, it is up to the parents what the children are going to do when they're minors. So, like I said, I would definitely get third-party external information to just try and figure out what is actually in the best interest of that child.
Yeah, Daniella,
and again, that's where parenting coordinator is.
Yes, you're right, and there's a need for that. I mean, the parenting coordinator it's a relatively new concept. It came in about, I think, after the Children's Act, about 2 years after the Children's Act. So for the last 8 years, maybe it came into operation with a user term facilitator and now parenting coordinator. But I think the parents need to understand something, and this I can bring to the table. I mean, almost practicing for 20 years on family law matters, is that the courts and the social workers and everybody over there, you won't necessarily get joy from the system. If parents come to the court, with a family law problem, related problem, sometimes in the judge's view or in the lawyer's view, it could be a very minor issue. You're fighting over Christmas Eve 1 or 2 hours. You're fighting over which school the child should go to, which is important, but the two options on the table are both good schools. So, why are we coming to court? Is this the way people are going to live their lives? Are they going to litigate on every specific topic? So, it's important for parents to understand that, and I'm trying to be frank and trying to just give a general way, people don't really care about your problems. We're dealing with your problems because we are getting paid to deal with it. We're dealing with the problems because it's important for us, because there's a minor child involved, so we need to do a proper job. We're dealing with the problem because we are the court, and we need to deal with it because we are, as I said, now paid to deal with it, etc. And of course, there are some people that do care, but it's a problem regarding you and your partner, your ex-partner or ex-spouse. You need to first try to resolve these specific topics. And if worst case scenario, and the absolute worst, and you cannot come to an agreement or resolve the issue, and it's very, very important, then I would say go to court, see a professional to resolve it. But it's so important that you note that you cannot go to a professional for every single minor problem. It's very important. Try to resolve the matter on your own. Be reasonable. Be how can I explain to you? Be logical. Don't just think because you have some money and you can afford a lawyer and you can afford a social worker, psychologist, etc., that I cannot go and litigate this matter and fight with the other party based upon that. Understand it. You're only one of the many thousands of cases that's on the roll that the court is dealing with. If, for whatever reason, you feel that a third party that doesn't know you at all can resolve your life with after 2 or 3 hours of looking into matter, then that's good for you. But please bear in mind that, you there's another file, you there's another matter. But if you need to see an advocate or an attorney or a social worker or psychologist, as the case may be, go to them. But please let it be the last resort. That's my final words.
I like the way you put that. I like how you said somebody can resolve my life in 2 hours. That's exactly what it boils down to. So I love that. But, my final thoughts then is just going to be, when you talk to psychologists and when you go down the road of psychotherapy, everything always is rooted in childhood or rooted in experience or something, and everything always builds on everything else. And I'm a firm believer that every single person on this planet has something that they should have, that they do have to deal with, be it minor, be it a self-esteem thing, be it a psychopathology, whatever the case may be. And I find that when people are willing to do the work on themselves, to understand themselves and their points of view better, you find most of the time that they become more agreeable and more understanding of what the child needs. So the reason I say this is because when we have a couple that is constantly arguing, I'll divulge a little bit, like this couple that I was talking about that was in mediation for 10 years. Eventually what I did with them is I separated them and I saw each of them on a personal level just to understand the way that they work. And after a couple of sessions, it actually turned out that they were so terribly unhappy apart that the only reason they were fighting so hard was because at least that meant that they would have time together, but neither of them would admit it. Once you get the opportunity to actually deal with what's going on with you personally, it is so much easier and so much it's so much easier to come to some sort of a resolution. So I always say, if you've got somebody that is always arguing, look at why they're always arguing, because it's very often not about the argument at all. And if we can give them the time to be there for them and understand them, and if they can commit to some sort of therapy where they can uncover all of these things, you find that they end up completely different, where there's no need, like desire to win at all, and they can put their swords down and they can actually start looking at what's best for the kids.
No, wonderful, Daniella. Thank you very much for that. We're running out of time here, so I think, Daniella, our topic next week will deal with the issue concerning guardianship rights, consent for passport applications, relocation, I think, purchasing of property for minor kids, Section 18.5 of the Children's Act. So we can touch on that aspect as well. We'll do David adult custody, the other issues concerning guardianship rights. To those people that make comments on our Facebook Live page, thank you very much. If you are watching this video or you have watched it now finish, please share it. Somebody else might find it useful. Daniella, please stay on the Zoom video. I'm going to chat to you after this, but I'll end off of this video now via the live connection. Thank you very much. Have a lovely day.